So it's on the basis of the above that we urge this honorable court to exercise its discretion in our favor. Thank you very much, my lord.
All right, dear. Thank you.
With all due respect to the applicants, it's my humble postulation that both applications, in the manner they are presented, amount to no more than legal contraband. And I urge your lordship not to touch them even with insulated fingers. In opposition to the application of the first defendant judgment debtor applicant, the claimant respondent filed a 30-paragraph affidavit. 30-paragraph affidavit on the 11th day of April 2025. My lord, we adopt that process. We have a written address filed on the same day. We adopt it as our address and submissions to this application. My lord, further, in response to the application filed by the second defendant applicant, we also filed a 32-paragraph affidavit on the 11th day of April 2025. We also have a written address attached to the counter affidavit. We also adopt those as our argument in this matter. My lord, I'll remind your lordship of a trinity of legal principles. Number one is that the judgment of a court of competent jurisdiction, like your court, is sacrosanct. It is valid and it subsists until displaced on appeal. That is settled. Number two, that a judgment creditor is entitled to reap the fruits of his judgment. He's entitled to harvest and reap the fruits. That's also settled principle of law. Number three, the burden hangs on an applicant in an application for stay of execution, like the proverbial sword of Damocles, to show exceptional circumstances why execution should be stayed. My lord, number one, I urge you to go through the affidavit evidence of the applicant with judicial telescope. There is nothing in the affidavit to persuade your lordship to grant such an application. Number one, the issue before your lordship under the radar is money judgment. Money judgment. In such circumstance, two principles apply. Number one, the applicant must show their earning. To show your lordship they are not able to pay the judgment debt. That they have not said. So they are well and able to pay the judgment debt. The next is that they must show that the respondent, the judgment creditor, is not able to refund the judgment debt if they succeed on appeal. My lord, I concede that we are not able to refund the judgment debt of $1.3 million, but we are able to refund the sum of $387,000, which is the cost of the properties of the claimant and his families that they repatriated from Dubai and left to perish at the Nigerian Ports Authority. That's what special damages found in favor of the applicant. The question is, this court sitting as a court of equity, will it be an equitable exercise of jurisdiction to allow the applicants to keep all the judgment debt, including the $387,000, which represents the value of his properties that were repatriated from Dubai, but allowed to perish at the Nigerian Ports Authority? I urge your lordship to examine scrupulously and meditatively our counter affidavit. Your lordship will have no problem in reaching the conclusion that the respondent has shown that he's able to refund that portion of the judgment sum. By the majestic provisions of Order 64 Rule 8 of the extant rules of this court, the law says they should deposit the entire judgment sum in an interest yielding bank account in the name of the deputy chief registrar of this court. We don't have a problem with that. We're only asking your lordship to amend that position. Let them pay to us the $387,000, which we can refund if the appeal succeeds. But the remainder of the judgment sum should be paid into an interest yielding bank account in the name of the deputy chief registrar of this court. The position of the law is that it will be inequitable to allow the judgment debtors to keep trading with the judgment sum while the respondent who fought for his case over 8 years and got judgment will be allowed to languish without having something to show for his judgment. I urge your lordship, as a court sitting in equity today, that the applicants have failed to disclose sufficient materials why this application should be granted in the manner they have presented it. I urge your lordship, we have suggested that Zenith Bank is able to take the judgment sum. Grant us that one. Let us hold it. They are going to an appeal. I urge you to examine the proposed grounds of appeal. They are commonplace, watery grounds. I can assure your lordship that by the time we get to the court of appeal, we will match them fire for fire, grit for grit, and rebellious arms for arms. I urge your lordship to grant this application conditionally. We have only allowed that as benevolent adversaries. Otherwise, you should be demanding for the entire sum. But we said no. As people who are minded to do equity, let them pay $1 million into an interest yielding bank account. Let the court hold it. But the $387,000 that represents our property, that they unconscionably sequestered at the Nigerian Ports Authority, including children's property, they should pay us for that. That's our position. We are grateful for the audience.
Thank you very much. So I'll soon be with you. Just give me a little time. I'll get back to you.
As a
I will not be long. I've been reading I've seen the files, I've seen everything before today, and I've gone through them extensively. I've read everybody's whatever. So just give me in 3 minutes time, I'll be with you. Just trying to correct some things on my write-up. Good morning, gentlemen. Can you hear me? Is
Yes, my
everybody?
lord. Yes, my lord. We can hear you, my lord.
All right. Okay. This is it's a very short ruling on this matter because, as far as I'm concerned, there are no extraneous matters that should take us longer than necessary. By a motion of notice dated the 3rd day of April 2025 and filed the same time, the same date, the judgment debtors applicants filed an application for sale execution. The judgment creditor respondent filed a counter affidavit on the 11th day of April. The court is aware of the implication of refusing an application for sale execution on the judgment sum and having same loss forever in the event the Court of Appeal reverses my decision. However, the grant or refusal of a sale execution is discretionary. The court must look at the extant factors in each case and apply its discretion as it deems fit. Ordinarily, a party that has obtained judgment in his favor is entitled to the fruit of his or her labor without waiting for that. The judgment of a court is correct and rightly made until the contrary is proved and established. See Professor V.O.S. Oluloyo and Adedapo Adediran 2001. But as has been said before, the preservation of the rest to ensure that the appeal, if successful, is not negatory. See the case of Holman Brothers and Kibo, Nigeria Limited. Godwin Basby Limited, 1980, Legalpedia, and Vaswani Trading Company and Savalak, 1972. In line with the above and the extant factors of this case and taking the pending application in view, and the rules of this honorable court, I hereby order that the judgment sums, all of it, shall be paid into the account of the Chief Registrar of the National Industrial Court pending the appeal so filed. This is my decision and I have entered it accordingly. It's a win-win situation for everybody. Hello?
My lord, we can hear you.
It's a win-win situation for everybody. Nobody is going to lose a dime. Once you finish at the Court of Appeal, whoever is the winner should come back and take all the judgment sum and the interest thereof, or whatever the Court of Appeal will decide. So nobody is in any danger. Yes, yes. Okay, call the next case. No problem, no problem, no problem. So pay the money into the Chief Registrar's account.
Thank you, my lord.
By the rules of our court, yes. And you go and face that appeal, and then whoever wins will come back and take it. Yes, and it will be a win-win situation. Nobody's going to lose anything. Yes. I think that is only fair to both sides. So call the next case, that one.
Thank you, my lord.
My lord, it's a matter for report of settlement. Number 1 case.
Okay.
Number NI/LA/14 between Farouk Abaje and one Chris Ifeanyi and another for report of settlement. Parties are absent.
All right.
Respectfully, my lord.
Yes.
C. Benoit Johnson, my lord.
Azarino, how are you?
I'm very fine, my lord.
I'm fine. Yes.
My lord.
My lord, I'm the claimant, my lord.
Oh, where is the claimant? Where is the claimant's counsel?
My lord.
Yes.
Yes. My name is C. Benoit Johnson, my lord. For the claimant,
All right.
my lord.
All right.
Yes, my lord.
Yes.
My lord, my name is Elo Azarino.
Okay.
With me, my lord, is my friend Juliet Wonsu. My lord, our appearance is for the defendant, my lord.
All right.
Yes, my lord. My lord, the parties have
Why say
agreed
asking me to start my
the
video?
matter amicably, my lord.
Why is so starting me to
And the
start my
terms of
video?
settlement have already been filed and should be before the honorable court. And my lord, we urge the court to please use this terms of settlement as consent judgments in this for the honorable court, my lord.
All right.
Yes.
Yes.
My lord, we confirm same position. My lord, the terms of settlement is dated the 25th day of March,
25th.
2025, and it's before this honorable court, my lord. My lord, we only plead that same be adopted as a consent judgment for both parties. The entire sum has been fully liquidated by the defendant as agreed, and all matters have basically parties have settled, my lord, and paid the sum. It's just for this term to be entered as a judgment of this honorable court. I'm most grateful, my lord.
So both parties are on the same page?
Yes, my lord. They've paid the money. They've paid the money. Parties have settled. It's just for these terms. This is the last last thing to be done, my lord.
The consent judgment is hereby granted, and I enter it accordingly.
As the court pleases. My lord, we're most grateful, my lord.
Thank you very much, gentlemen. Thank you very much, gentlemen. Have a nice day.
You too, my lord.
All right. Call the next case.
So number NICN/LA/422/2022 between Adebisi Omojola and Citibank Nigeria Limited. Milopat is absent.
All right.
Are you sure?
Yes.
Adebisi is online. Is she not the one there?
The claimant is.
About me, Alagbada, you are for who?
I'm for the claimant, my lord. Good morning, my lord.
Okay. The claimant also is here.
Claimant is present. Claimant is present.
Okay. Yes.
My lord, Abayomi Alagbada appears for the claimant. Grateful, sir.
No, I've already taken your appearance. Where is the defendant counsel?
May it please this honorable court. I am Peace Adeleye, and with me is Choma Egbowanchukwu. Choma Egbowanchukwu is spelled
Slow down. Your name?
My name is Peace Adeleye.
Okay.
Yeah, with me is Choma Egbowanchukwu. Egbowanchukwu is spelled EGBOH, dash a compound name.
Okay.
And Chukurat Oladejo. Oladejo is LOLADEJO. Together, we announce appearance for the defendant's applicants.
Okay. It's all right. I've looked at your documents, I've read them thoroughly, and I have a very short ruling for you. About you, what's funny?
I'm amazed at the industry of my lord. You know, even when my lord is
everything, the technology also has helped a lot. Yes.
We're grateful.
Yes. So it's a short ruling. By a motion on notice dated the 16th day of April 2025 and filed on the 17th day of April 2025, the defendant applicants sought an order staying proceedings pending the hearing and determination of an appeal by the Court of Appeal. The claimant respondent has filed a counter affidavit on the 2nd day of May 2025 in opposition. I've gone through the process filed and the argument of counsel contained therein. From the facts, I agree that to preserve the rest pending the determination of the appeal is the right thing to do. The respondent has argued that what was filed in leave to file is leave to file an appeal, and that is not an appeal by itself. It is tried that mere filing of a leave to file an appeal does not operate as stay. However, it is desirable that the trial court stay proceedings upon becoming aware of the appeal or leave, as in this case, in order to avoid a situation of conflicting decisions, which probably could render the decision of the appellate court useless and negatory. I hereby grant the application for stay pending the determination of the Court of Appeal.
As the court pleases.
That's my ruling. I was only trying to save you moving a document. I've seen everything you've said.
My lord, my lord, it's we take the ruling of the court, even though
yes,
we are at the receiving end. It's unfortunate.
No, just make sure that you go after. Anyway, lawyers are doing themselves these days because we are supposed to be professional. We are supposed to be very. Is it not a ruling that was appealed?
Just the ruling to amend our process. They are saying we cannot amend. Haven't
well,
an employee in the middle of a case.
Anyway, I wouldn't want to go into the issues of the case at this moment. Just let's see what the Court of Appeal will see, and then we'll take it out from there.
We are grateful to your lordship. We are grateful.
Thank you very much.
Thank you, my lord.
All right. Have a nice day.